Hi there, my name is Katie Hubler, and I'll be teaching class today. We're going to be going over pages 155 to 165, and I'm really excited. Today we're going to be getting into copyrights. I think that this topic is super interesting, especially when we start talking about copyright when it comes to music or works of literature. I think it's really, really interesting and I'd love to talk about it sometime. So, to get us started, I thought I would talk about the controls that a creator has once they get their work copyrighted. This was mentioned in the last chapter, but I just thought I would use it as a preface before we really get into it. So, once a creator copyrights their work, they get to control the reproduction, the performance, the derivative works, and the distribution, as well as public display. So we start this chapter off talking about licensing performance rights. So licensing music is normally used in restaurants, malls, mainly just public places. And this is something that you do specifically for music to be played somewhere, not to be used for commercial use or reproduction. I just want to get that clear. So basically, to license something, you go through ASCAP, BMI, any sort of licensing agency, and many businesses that are playing music pay what is called a blanket license. And this allows users to pay for an entire year's worth of music, no matter how much they use it or listen to. And this is all based on revenue for the business. So each business kind of pays a different amount. The only real exemptions to people getting licensed music is A, if the business is really, really small, or B, if they have something like the record store exemption. I thought this was really interesting. So basically, you are exempt from using licensed work if you are trying to sell that work. So, for instance, you go to a record store and they are trying to sell you a brand new album. In order to market that album and get people to buy the album, they're going to play it for you. So in this instance, you would be exempt, which I think is really cool. All right, moving on. Next, our book touches on music in politics as well as songwriters' rights. So the book touches on when Donald Trump used Neil Young's song during a rally, and Neil Young was really upset about it. And basically, as long as Donald Trump was paying some sort of license to ASCAP, he's totally able to use Neil Young's song during a rally or political event. However, if Donald Trump were to try and use this song for commercial use, such as like in a commercial or on his website, something like that, then that would lead to a problem. So, although Neil Young might not agree with Donald Trump's presidency, might not agree with what he believes, might not want him to use his song, as long as Donald Trump is paying a licensing agency to use it, he is totally allowed to do that. Next, in our book, we touch on derivative works. So, derivative works are another part of a creator's sort of rights. So, a derivative work is a new form of work that is derived from something older. So, the most kind of well known situation of this is covers of songs. So, in the example here, I have the newest Weezer album, and in this album, every single song is like a cover. So they did a cover of Africa by Toto and Mr. Blue Sky and all of this other stuff, which is really cool. But in the same token, Although it's a new sort of form of this work, it still belongs to the original artist. So the original artist still gets compensation from this. Although that music covers are the most well-known example of derivative works, it's important to note that they're not the only example. Literature can be a derivative work. Pretty much anything can. An example would be the fact that there was a play written about the Harry Potter books. So although J.K. Rowling wrote all of the Harry Potter books, someone went and wrote a play, which is an entirely new, different work but at the same time, it is still derived from J.K. Rowling's literature. Therefore, she should be compensated because she's the original artist. Moving on, the book touches on the exceptions to distribution rights. So the first one that they talk about is the doctrine of first sales. So this means that the author still owns the intellectual property of this work of art, but the buyer owns the copy of it. So the most common example of this is a library. So the author owns the intellectual property of the book they wrote. However, the library purchases and owns a specific copy of it. And with that copy, they are able to do whatever they want with it. In this example, they're able to check it in and out to different people. Something that I didn't know that I learned in the book is that although the doctrine of first sale applies to books, it doesn't apply to music. So if your friend receives a CD and is making copies of it or giving it to people to download, that is actually not legal. I did not know that. So next, the book touches on EULAs, which is an end user agreement license, and this is specifically for software. So it's also not legal to be distributing and redistributing software. So once you download a piece of software or you buy software and you remove the wrapping, you accept their offered terms and conditions. Next, the book touches on music in the digital age and what that sort of means, because we've passed the days of going to the record store, buying CDs, stuff like that, and we've even passed the days of going on iTunes and paying 99 cents to download a song. We're now all just paying monthly fees to Spotify to stream our music, which is awesome and incredibly convenient for us, but what does that mean for artists in terms of compensation? This sort of fight that Taylor Swift was having was between the Copyright Royalty Board, which is a board of 3 judges that decide the terms and rates for streaming and copyright licensing. Next, the book touches on what actually can you copyright, and you can pretty much copyright anything. To name the examples, the book mentions literary works, dramatic works, motion pictures and movies, sounds and audio, architecture, musical works, choreography. The list goes on and on and on. You can pretty much copyright anything. However, there are a few sort of requirements. The first big one is that it has to be something of like a tangible medium, so it kind of has to exist. And the second requirement is that you can't copyright an idea. So let's say you're thinking something and you have this idea and you want to copyright it. You can't do that. In the same token, you can't have an idea and then say that someone stole your idea or something like that. It doesn't work like that. Once you have something that you want to copyright and it's a tangible medium, it's a good idea to register it. This is no longer a law, but it's a really good idea, just in case someone ends up trying to steal your art, this will help you claim more damages if you end up registering it. The only exception is in works for hire, where the copyright duration is set at 75 years. So a works for hire basically means that your work belongs to the business that you work for. So if you work for the New York Times and you write an article for them, technically like you produce the work. However, it was produced produced with the company, produced using the company's resources. So at the end of the day, the company owns the copyright, even though you wrote it. Next, we are going to be talking about copyright duration, and the book describes copyright duration as the most contentious area of copyright law, meaning that there have been tons of times where the length of time for a copyright to expire has been extended or other rules have been made and whatnot. The current copyright law, the most recent change to the length, was in 1998 when Sonny Bono Copyright Term Extension Act was passed, which added 20 years on to the duration of the 50 years. So instead of it having to be the life of the author plus 50 years, it's now the life of the author plus 70 years. Finally, the book touches on substantial similarities, and I find this to be so interesting. So substantial similarities is totally different from derivative works, which we discussed in the beginning of the video. So substantial similarities is when a author makes separate work, but there is substantial similarities found in another piece of work. So unlike a derivative work where the author of the second work derives their art from the first author, this person is claiming that it is a separate piece of work, and there are people who claim that there are substantial similarities found. The book mentions a few examples of substantial similarities, but one that I specifically remember happening is with Tom Petty and Sam Smith. So a few years ago, Sam Smith put out a single titled Stay With Me, and Tom Petty heard it and found substantial similarities in the chord progression of that song to his song, Won't Back Down. I actually went ahead and did a little more research on this, and according to The Sun, Sam Smith and Tom Petty actually ended up settling out of court, and Sam Smith ended up giving writing royalties to Tom Petty on this song. Next, the book talks about the doctrine of fair use, and the doctrine of fair use is basically stating that when fair use is claimed in a copyrighted work, that the author doesn't get all of the controls when it comes to the work. When something is fair use, the copyright holders don't really get a say in what can or can't happen with their work. They can't prevent what happens, and they're also not able to receive compensation if it's considered fair use. When deciding if something is fair use, the things that are considered are the purpose of the use, the nature, as well as the amount of sustainability and the effort of use upon the potential market for or value of the copyrighted work. I wish I could go more into depth about these 4 things, but we will get into that in our next reading. So for now, I just decided to gloss over them, and that looks like I'm about out of time. So thank you so much for listening. I love talking to you guys today. I hope you enjoyed my presentation. I would love to talk about this in class. Thank you so much for having me. Have a good one.